Good morning, everyone. Today, the topic under CPC which I have taken is the difference between decree, judgment, and order. Generally, all the three we frequently interchangeably use them, but still, there is a need to draw the difference between decree, judgment, as well as order. In the first one, I have taken the difference between decree and judgment. Decree is defined in section 2.2 of CPC, and whereas judgment is defined in section 2.9 of CPC. If we see the differences and similarities, of course, I can't say that there are completely differences, but we also find some similarities too. In the first one, if the first difference, if you see that it is a decree is the formal expression of adjudication, and the judgment is also formal expression of adjudication. Formal expression of adjudication means it is an official expression. It is the final expression as to the contents of the case, complete final verdict of the case by the competent court. In both cases, we find that it is one of the similarities we find both for decree as well as judgment. If we come to the second one, decree is the concise form of the judgment. Concise form means a brief part of the judgment. In this, you don't find the complete story of the case, but whereas in judgment, it is full description of the case. That means the complete details of the case we can find if we want to pick out, if we want to search for any case, the details of parties, trial proceedings, arguments, and examinations, witnesses, evidences, what actually the proceedings that took place before the court. If you want to know each and every point, we have to search and see the judgments. In judgment, it is going to give the full elaborative description of the case. But in decree, you don't find it. It is a brief part of the judgment. And the next one is the decree. It is going to lay down the points for determination. That means on what point they have decided the case. And this is also similarity in case of judgment. In judgment also we find the same one, that points for determination. And the fourth one is the decree is going to assign the reasons for on what ground the court has taken the decision. It is nothing but we all know that it is one of the principles of natural justice. We must assign the reasons on what basis, on what grounds actually the court has taken the decision. The reason behind it is the party, he must know against whom actually the decree is passed, that is judgment data. He must know actually the grounds why the decree has been passed against him, and we are giving him the information, the ground why he has been put to some loss in that particular case, so that where you are giving some knowledge to that particular judgment data, there is a chance that he can move to the appellate court on that said grounds. He may feel that those grounds may be correct, those grounds may not be correct. It is giving because the layman's will be there, lawman will be there. First of all, it is nothing but a natural justice principle. Natural justice principle. You must know why the decision has been passed against you. If you know that, if you feel that that particular ground on which the court has taken the decision, if you feel that it is right, you may not even approach the higher court. If you feel that whatever the ground on which the decision is taken by the court is wrong, if you feel and if you are aggrieved, if you are feeling aggrieved by that, there is a chance that you can move to the appellate court, the reasons for the decision. If we come to, this is also known as in our administrative law, we have come across the word speaking order. Speaking order means the order itself speaks the reasons why the decisions have been passed, on what grounds, what are the points that have been taken into consideration for passing the decision. It must be known to the parties so that they can move to the next appellate court if they feel that they are aggrieved by the decision. In both the cases, decree as well as judgment, reasons for decision will be there. And the next one is it may be preliminary, final, or partly preliminary, partly final. That means kinds of decrees will be there. Decree may be preliminary decree, final decree, or in some cases it may be partly preliminary and partly final. Especially where the cases of the partition suits are taking place, generally we also find two types of decrees. Compulsorily we may be having, that is preliminary decree and final decree. But we don't find that judgment will be preliminary and final. In judgments only we'll be having only one type, final judgment. And if we come to the last one, decree is appealable in nature, but whereas judgment is not appealable. That means if we have to move to the appellate court or higher court, next higher court, we need to have in our hand that a decree. It is not enough that if you are having simply judgment, the judgment is not directly appealable. The judgment has to be converted into decree, and then only on that decree only appeal lies. So decrees are appealable but not judgments. In the next one, let us see the difference between decree and order. Decree is defined under section 2.2, whereas orders were defined under section 214, 1/4. 2 clause 1/4 order is defined. In CPC, please don't get confused, the students especially. Orders, we are using the word order which will be having different meanings. In the first, if we see superficially the CPC, you are going to see that the CPC is divided into two parts. The first part is containing completely 158 section, and the second part is first schedule, which is going to give the orders and rules. Those orders and this order is not one and the same. There, the orders are meant for the easy moving of the proceedings before the court and giving some flexibility to the parties to take up any proceeding before the law court. But whereas here the order means, the inference here, the meaning is it is a decision by the court. That is the difference, that it is not under first part where the superficial structure is there as to the CPC. That order, whatever we are saying, that 51 orders be there in CPC, that order is not same as to the order which we are using under section 214. Now, here the order means it is a decision. Now, come to the first difference. Decree shall be passed only in suit. Here, you people must understand that if there is a decree, our presumption has to go to that the plaintiff should have dropped the plaint. If there is only presence of plaint only, you call those proceedings as suit proceedings, and they are ending with the decree part. So decree shall be passed only in the suit. If it is a suit proceedings only, you find the element of the decree. If it is not a suit proceeding before the court, you don't use the word the decree, even though some decision is given by the court. Here, order shall be passed in any proceedings by the court. That means it is not only in suit. We have to say that orders may be passed by the court. We may be coming across so many orders also be passed by the court. But those orders will not constitute and will not be called as a decree. Different types of proceedings be taking place before the court. That may be by filing some applications, by filing petitions, not only suit, but also some other applications wherever that is filed by the parties. In respect of those applications or proceedings, the court may be passing some decision which is not constituting definitely the element of the suit. So orders may be passed in any proceeding by the court, but decree shall be passed only in the suit. It may be any proceeding, it is only in suit. Come to the next difference. Decree may be in any kind. That is, just now I have given, it may be preliminary, final, or partly preliminary and partly final. But there will not be any kind of such differences in orders. You don't say that it is a preliminary order or final order. Such kind will not be there. Shall be passed at the end of the proceedings only. Decree means it is coming only at the end of after the conclusion of the trial proceedings only, you will get the judgment, and which is converted into decree. That means it is the last and final stage in the proceedings of the suit. But if we come to the order, if we see the order may be passed at any stage of the proceedings. Right from beginning till the end of the case, multiple orders may be passed by the court depending upon the facts and circumstances. But a decree must be always only one, that too at the conclusive stages. Now come to the next fourth one. It shall be passed only by the court. That means the decree is capable of being passed only by the court. The court is only competent to pass the decree. But if we come to the orders, order may be passed by any authority which is competent, maybe an executive authority, or it may be a tribunal which is passing the decisions. They are also constituting the element. It is known as orders. Executive orders will be passed. Tribunal is passing the decisions in the form of the orders. It may be passed not only by the court but also by any other authority apart from the court. Now, next one is decrees conclusively determining the rights of the parties. Here, you people have to understand the point. It is conclusively determining the rights of the part. Decree the means it is, since I am saying that it is the final and the last stage, it is going to finally conclusively it is determining the rights of the parties. But in case of the orders, it may happen or it may not happen. Sometimes it may be conclusively deciding also. Sometimes wherever intermediary proceedings are taking place before the law court, as to the emergency matters, in such cases, it may not conclusively determine the parties to meet the emergency situations then and there, where the court is also satisfied that immediately some decision is required in respect of some aspect which is whichever that is sought by the party. Under those circumstances, the court may be passing some orders which may not conclusively determine the rights. It may determine, it may not determine. Always the orders may not determine or they may be determining also. Both the cases may take place. But if it is a decree, always our understanding is it is going to determine the rights of the parties conclusively. And the last one is the decree shall have the second appeal also in some cases. Always first appeal will be there, but whereas to the second appeal is subjected to some conditions. But if we see the orders whether it is appealable or not, the first appeal, only first appeal is lying. Here, these are the important differences between decree and order. Next topic I am going to take what is the proceedings, what are the steps involved in the proceedings before the civil court whenever I am coming up before you.